Welcome all to the new class on administrative law. This is about a case law and this is Dr. K. Sangeeta. So ADM Jabalpur versus Shivkant Shukla. Here the citation is 1976 and the details are given here. As to date of judgment, it was 28/4/1976. The bench consisting of Ray, Khanna, Hansraj, Beham, Hamidullah, Chandrashud and Justice Bahodi. First we will see the brief facts of the case. On June 25, 1975, the President, in exercise of his powers conferred by Clause 2 of Article 352 of the Constitution, declared that the grave emergency exists whereby the security of India is threatened by internal disturbances. On June 27, 1975, in exercise of his powers conferred by Clause 1 of Article 359, the President declared that the right of any person, including a foreigner, to move to any court for enforcement of the rights conferred by Article 14, 21 and 22 of the Constitution, all proceedings pending in any court for the enforcement of the above mentioned rights shall remain suspended for the period during which the proclamation of emergency exists. The President Order of June 27, 1975 further stated that the same shall be in addition to and not in derogation of any order made before the date of the aforesaid order under Clause 1 of Article 359 of the Constitution. On June 29, 1975, by another order, the President made it very clear that the Ordinance of June 27, 1975 is applicable to state of Jammu and Kashmir as well. The President proclaimed the amending Ordinance number 1 and 7 of 1975 and replaced by the Maintenance of Internal Security Amending Act number 39 of 1975 Act, introducing a new section 16A and giving a deemed effect to section 7 of the Act as on from June 25, 1975, while the rest having a deemed effect from June 29, 1975. By the same Act, a new section 18 was also inserted with effect from June 25, 1975. On October 17, 1975, an Ordinance 16 of 1975 was issued making further amendment to Section 16 capital A of the Maintenance of Internal Security Act, introducing subclause 8 and 9 of Section 16 capital A. On November 16, 1975, Ordinance 22 of 1975 was issued making certain amendments in the Maintenance of Internal Security Act, inserting also subsection 2A to section 16A. All the amendments made by the ordinance were given retrospective effect for the purpose of validating all the acts done previously. The said ordinance was published as the Maintenance of Internal Security Amendment Act 1976, Act 14 of 1976, on January 5, 1976. The respondents declared under Section 3(1)(a), Clause 2, read with Section 3(2) of the Maintenance of Internal Security Act. The Act was challenged in several high courts. The virus of the Ordinance issued on June 27, 1975 by the President of India as unconstitutional and inoperative in law, and prayed that the setting aside of the said order, second, for directing their release forthwith. In some cases, they challenged the validity of 38 to 39 Constitution Amendment Act. When these petitions came up for hearing, the appellant raised the preliminary objection to the maintainability on the ground that in asking for a release by the issuance of a writ of habeas corpus, the respondents were in substance claiming that they have been deprived of their personal liberty in violation of the procedure established by law, which plea was available to them under Article 21 of the Constitution, only in the view of Presidential Order dated June 27, 1975, suspending the rights to move for their enforcement of the rights conferred by that article. The petitions were liable to be dismissed at the threshold. While the High Court of Andhra Pradesh, Kerala, Madras have upheld, the preliminary objection said that this contention did not find favour with the High Courts of Allahabad, Bombay, which was Nagpur bench then, Delhi, Karnataka, Madhya Pradesh, Punjab, Haryana respectively. The state and the central government, being agreed by the decision of the various High Courts, filed an appeal before the Honorable Supreme Court. Issues. First, whether a writ petition under Article 226 before a High Court is maintainable to enforce the right to personal liberty during an emergency declared under Article 359 Clause 1 of the Constitution. Second, if such a petition is maintainable, what is the scope of judicial scrutiny in the view of presidential order? The law relating to ADM JAPALPUR case. First, the Constitution of India under Article 21 says that no person shall be deprived of his life or personal liberty except according to the procedure established by law. Essential ingredients of Article 359(1) are proclamation of an emergency must be in operation. The President may order not to move to any court for the enforcement of the fundamental rights under Part 3 of the Indian Constitution. By any such order, the proceedings for the enforcement of the right shall remain suspended for the period during the proclamation when it is in force. Now we will see the difference between Article 358 suspends the rights only in Article 19 to the extent that the legislature can make law contravening Article 19 during the operation of proclamation of emergency. The executive can take any action which the executive is competent to make under such law. Article 358 does not suspend any fundamental right. While a proclamation of emergency is in operation, the presidential order under Article 359(1) can suspend the enforcement of any or all fundamental rights. Article 359(1) also suspends any pending procedure for the enforcement of the fundamental rights or rights. Arguments on behalf of the parties. Appellate 1. The state does not release a detainee despite the opinion of the advisory board that there is no sufficient cause for this detention and thus keeps him in detention in flagrant violation of the provision of Article 22. No habeas corpus petition would be maintainable, and this would be so though Article 22 itself is a fundamental right. The right to move to a court for enforcement of a right under Article 19 has now been suspended by the President under an order issued under Article 359 subclause 1. Second, suspending the right of a person to move to any court for enforcement of the right to life and personal liberty is done under the constitutional provision, and therefore it cannot be said that the resulting situation would mean the absence of rule of law. Now for the respondent. According to the respondent, the limited object of Article 359(1) is to remove the restriction on the power of the legislature so that during the operation of emergency it would be free to make law in violation of fundamental rights specified in the presidential order. The argument proceeds that there being a valid law regulating preventive detention, namely the MISA, even every order of the detention passed by the executive must confirm the condition prescribed by law. The respondent argument that Article 21 is not the sole repository of the right of life and personal liberty. Next, non-fundamental constitutional right like those arising under Article 256, 265 and 361 subclause 3 are natural rights and contractual rights or the statutory right to personal liberty and are not affected by a presidential order. Statutory rights can only be taken away in terms of a statute and not by an executive order. Finally, it is urged that the preamble to the Constitution speaks a sovereign democratic republic. Therefore, the executive, which is subordinate to the legislature, cannot act to the prejudice of its citizens, say to the extent permitted by law, validly made by a legislature which is chosen representative of the people. Thank you.